Oh, hello. We have people in the chat. Sorry, everybody, I was doing work. Okay. Sean S says, good afternoon, Vince. Good afternoon, Sean S. Insert promo here says, happy Labor Day. Happy Labor Day to you. Yo Cannon says, hi, Vince. Hi, Yo Cannon. I hope I say your username correctly. My other channel says, good morning, Vince, and others. Marcella Lou says, good morning from Texas, Vince. Is it odd if your attorney does not pay you your settlement out of their trust account? Okay, Marcel Lewis, that is a great question. So let's read that question one more time. We are going to jump right into it. Let's get a little coffee here. Okay. And yeah, it's Starbucks today, which is tragic. Very, very sad. We don't like the Starbucks here, but Dunkin' Donuts gives its staff Labor Day off, and Starbucks doesn't care about their staff. So you got to do what you got to do. Excuse me. All right. Marcelo Lewis says, good morning from Texas. Is it odd if your attorney does not pay you your settlement out of their trust account? Not necessarily. So a lot of attorneys in this field will have the check go to you directly from the defendant or the respondent, depending on where your case is filed. Excuse me. And that is fairly normal. If the check is coming to you from an operating account from your attorney, that might be a little bit odd, especially if it's a large check. But normally you're going to want, if your attorney is holding the money for you, it will be in an IOLA or a trust account of some kind. In rare circumstances, I guess, depending on the state and the jurisdiction, it could be coming from their operating account, but that's an ethical issue that changes, I think, state by state and is somewhat situational. But Marcella Lewis, the most common thing that I see is that the check comes directly from the defendants at this point, the bad guys. Yvonne says, hello from New York. I am, in fact, in New York this moment. So hello from New York as well. My settlement check is in the mail, but I want to say thank you for all your advice. I am so glad that your settlement check is in the mail. I am thrilled for you. I applaud you and your victory, and I hope that you've been made whole. Ramona Hudson, good afternoon to you as well. Yo Cannon says, are pre-litigation settlements categorized into damages, or are they just one lump sum of money? Generally, Yo Cannon, when you are negotiating pre-litigation settlements, you are still talking about various categories of damages. And it does matter a little bit because certain categories of damages can go on a 1099 in certain situations, while everything else, the economic damage especially, has to go on a W-2. So there is some time spent categorizing damages. Ramona Hudson says, how could I tell if my lawyer is lowballing my settlement amount? Ramona, we have multiple videos on this about case flippers and, telling if your attorney is doing that to you. The quickest answer is ask them why, right? Ask them to explain the settlement amount that they're advising to you, and then hit up our damages calculation playlist and do your own damages calculation and do your own thought process as to the risks in your case, right? Like if their answer is well-reasoned and it fits the formulas for the damages and you think it intelligently hedges for risk, then they're probably not lowballing, right? If they won't explain or they can't explain, or if their explanation doesn't really hold water in your eyes, then it's possible they're lowballing your settlement offer. Just a quick way to go about it. But I would watch those videos on the channel. So we have a lot of videos. We probably have like a couple hours of content about people attorneys flipping cases and lowballing settlement offers and stuff like that. So, there's going to be a lot more there than I can do in a live stream. Marcelo Lewis, my pleasure. I hope it helps. Ray Merrill says, I worked at Walmart for 4 months. I had PTSD and took a leave of absence. Obviously, Walmart approved the leave of absence. I had the documents from my doctor. When I returned to work, the team lead fired me. Is this a small damage? I don't know what your damages are. I mean, your damages would be your economic damage, your emotional damages, and potentially maybe not any punitive damages in what you're relaying here, but that's going to depend where you are. Is it a claim? Yeah, I think it's a potential claim. If you feel you were fired because you took a leave for your PTSD, which is a federally recognized disability, then yeah, that's a claim. I think you should be speaking with employment attorneys about that. I'm not going to do a damages calculation for you. I mean, a lot of Walmart workers, in my experience, tend to earn between $20,000 and $40,000, depending where they are, depending how many hours they work. So, listen, that could be a case worth somewhere between $10,000 and $100,000. It could be worth more than that, frankly. Certainly it's a quality potential claim. Toxiholic says, good afternoon, Vince. My lawyer said my lawsuit will take 2 to 3 years. I have mediation starting November 11th. What is the likelihood for them settling the case before the 2-year period? I can tell you that, well, listen, I don't know what the likelihood of them settling your case is because I don't know where you are and I don't know how good your case is and I don't know how much you're demanding and I don't know who your attorney is. And, there's a lot of things I don't know. But I can tell you within our firm, north of 98, let me be a little careful here. North of 95% for sure of our cases resolved before the 2-year mark. So, if that informs you, that might be helpful. Now, listen, every case is different, every plaintiff's different, every defendant's different, but that's just my guess. Summer, my pleasure. Happy to share knowledge. Kelsey says, when suing a city government, whoa, we already have 38 people concurrently. Whoa, you guys all showed up. I barely, I didn't do anything to publicize this. I put up like one post. I didn't even post the live stream until I was actually supposed to be going live. I was like running to get in here today because I knew that I had promised to go live at noon. All right, back to questions. Kelsey says, when suing a city government, who on the defendant side decides whether to settle the case? Often, and listen, every city is run a little bit differently, but there's often a comptroller who decides. There can be authority given to attorneys. Like in New York City, you'll find that New York City Corp Counsel, like Special Fed, has fairly broad discretion to settle cases. They can generally cough up a 6-figure settlement without too much oversight. But there is fundamentally going to be like an agency head who has something to say about it in New York. There's going to be a comptroller. Like there's multiple voices. And it's a little bit different from city to city, Kelsey. Ramona Hudson says, Vince, I have 5 charges in one EEOC case and it's severe. Do you think I'll see 6 figures? The number of charges you have has nothing to do with the valuation of your case. Now, it being severe means that very well it could be a 6-figure case, right? Like that could be, if what was done to you is really shocking and terrible, then yeah, there's a good chance that it's going to increase the damages. And you might have a 6-figure case. But Ramona, I would urge you to maybe hit up our damages calculation playlist to get an idea of how the damages are calculated, because you can apply that playlist to the facts of your case and get a better deal to the actual valuation than I can provide you in a live stream. Aaron R says, hey, Vince, thanks for all the advice you post. My pleasure. I hope it's of some value. I went to mediation on Thursday. Employer didn't even show up. The HR woman was there, but had the mediator on hold every time she called the owner. I hate that. Oh, Aaron goes on. Total waste of time. Just wanted to pass a laugh on. Yeah, I hate when they come without authority. It's such a waste of time, and I don't understand the logic of it at all. Like, I don't understand why you would like waste the mediation. But even if you don't want to settle, like, why then just decline the mediation? Like, why? They certainly would know that you're not paying your attorney hourly. Like, what's the point in sending this HR lady to do nothing, right? Toxiholic says, we haven't talked the settlement amount. They just amended my EEOC claim. I filed that on January 25th of 2024. The charge wasn't filed until July 18th, 2024. Cool. Very cool. Marine Carium says, hey, Vince, will a cause finding from the EEOC make it easier for me to hire an attorney? Potentially. Yeah. Pig Patrol says, Vince, can you tug on your hair real slow to show it's not a wig? Yeah. What do you want me to do? You want to, Is that what you're looking for? What are we? You think I wear a wig? That's fantastic. I mean, like, what are we? I mean, I am like balding a little bit, but it's like my hair used to come down to like here, and it's just like going up, if that helps. Like, that's my hair loss. Also, my hair is all white on the sides. I don't know if you can always see that in videos. Ramona Hudson says, we have over 500 employees. Amazing. You're going to be well filed in the EEOC then. Certainly you meet the criteria there. Aaron R says, no counter offer, just a half day sitting at the attorney's office. That's such a waste of time, Aaron. I'm so sorry they did that to you. Big Will, great username. Big Will Big Wheel, I feel like you might have been somebody I grew up with. I mean, you're not because you're in Florida, but like with a nickname like Big Will, I might have grown up with you. I'm in Florida. I filed with the FCHR. The respondent has never responded with a position statement. Will the FCHR rule in my favor with just my narrative? I mean, listen, I'm not allowed to tell you what the FCHR will do because that is a state agency, but like I can tell you that if you had a good narrative and that it fit the elements of a claim and I was an arbitrator and it was in front of me, I would find for you. So I would hope they might as well. Insert promo here says, 1, is a violation of the institution's anti-discrimination policy strong evidence? Meh. Can be. Depends on the context. Mr. Cato ASMR, what comes first, a mandatory settlement conference or a motion summary judgment? Oh, okay. So a motion for summary judgment is post-discovery. If you're in federal court, Mr. Cato ASMR. By the way, Mr. Cato ASMR, good to see you again. It's been a while. Summary judgment motions happen way like right before trial, frankly. So you've gone through the motion to dismiss potentially. You've had, a complaint was filed, an answer was filed. Maybe there's a motion to dismiss phase. Then there was all the discovery took place, and then you would have a potential summary judgment phase before trial. So it's way down the line. Most federal courts, in my experience, are going to out of the gate right after the answer is filed schedule mandatory mediation, but different courts do different things. Insert promo here says, 2, is it possible to be awarded education expenses in the case that that intending to attend graduate school, PhD, and professional degrees was a condition of the employment? Sure. If some of the compensation you were receiving was tuition reimbursement, then you absolutely could seek that as part of your damages. Marcelo Lewis says, can the defendant be in breach of contract if a coworker approached you and told you that the defendant told them how much you were settling for? The settlement was only verbally agreed upon. Well, if the settlement was only verbally agreed upon, then it might be difficult for them to have breached an agreement because there would have been no agreement in place, right? So if you're just talking numbers back and forth, that first off, that defendant is very stupid for telling your numbers. That's incredibly stupid on their part. But that being said, if there's no contract, there's no settlement agreement, right, which is a contract, there's nothing for them to breach. There's no terms in the contract that doesn't exist yet that says they can't tell people. Now, they might have breached a mediation term sheet, and that could have some ramifications, but they wouldn't necessarily be a breach of a settlement agreement, at least. Ronix Macaria says, my discrimination case is also criminal. I have filed the EEOC and the Texas Workforce Commission, and I qualify for unemployment fast. Employer has no defense, but I cannot find a lawyer in my city. Okay, so first and foremost, Texas is super weird when it comes to finding employment attorneys. Like I think I've shared this story on the channel before. Like, young woman working at a fast food restaurant, without objectifying her, beautiful young woman. Dude starts groping her. There's a struggle. Dude like holds her down. Horrible burns on her face, disfigured for life during like a sexual harassment, sexual assault incident. And that young woman was turned down by multiple employment attorneys in Texas. I believe her without question that she had multiple rejection notices. So sexual assault with witnesses, permanent physical disfiguration, criminal charges that he eventually pled guilty to. And these attorneys are like, I'm good. I'm all right. Obviously, we took that case, right? I mean, obviously, but and did right by that person. But it blows my mind. Like, I think if I was like a PI attorney in Texas and that case walked in my door, I'd be like, yep, sign it up. We'll figure it out. That's obviously a case. Like, I don't understand how an actual employment attorney practicing in Texas could be like, yeah, I don't want this $500,000. Like, even if you're a bad person, you're still gonna be greedy. Help the lady, make the money. I don't understand. So listen, Texas is crazy when you say that. Now, the second part of let's go back to the second part you said. Your discrimination case is also criminal. So when discrimination cases are criminal, you have a second action going on that is important to your case because one, there's going to be there's going to be evidence that comes out in the course of that criminal action that can be valuable to you. Also, often, criminal defendants will end up taking plea deals in which they plead guilty because they're afraid of going to jail. And that's going to be amazing for you because they're like, well, in the civil case, well, listen, the employer's like, we don't know what really happened. Like, oh, but the guy that we said did the bad thing says this happened because he pled guilty to it in the criminal action. And in pleading guilty, he said he did it. So the two people who are there, my client and your idiot who worked for you, best case scenario idiot, probably way worse than idiot. 100% of the people involved in this altercation say it happened like I say it happened, right? You can see perhaps the advantage to that situation, and you need to use the criminal action accordingly for your purposes. All right. Silence is golden. YouTube users, whoa, chat jumping ahead. Chat, you got to chill out. Whoa, we have 51 concurrent right now. That might be a new channel record. I think we might have topped that at 60. I don't really know. All right. YouTube user Silence and Golden. I went back and found the question. Is it normal for an employer to continue to retaliate after they receive a letter of representation from the employee? And even the management knows the employed had an attorney. I appreciate you. I appreciate you. So no, it is not normal. It is rare. It is incredibly rare. It does happen, though. Most employers are smart enough to know that when they get a letter from an attorney in this field, you go hire specialized counsel. First thing specialized counsel does is make sure they don't retaliate. That's defense counsel, employment defense counsel, specialized counsel. Now, what sometimes will happen is that employer gets a letter from a law firm like ours, and they go hire their general purpose attorney, or they stick with an in-house attorney who maybe doesn't know a lot about employment law. And more, we're seeing in-house counsel hop out of the in-house world for like 3 to 5 years and do stints in the realm of employment law, because employment law is becoming a bigger and bigger part of what imperils corporations these days as our industry grows. But you will see in-house counsel or general purpose counsel or just corporate counsel who just don't know what they're doing, and they might not properly advise the employer, and there might be retaliation. So Silence is golden. It's rare, but it does happen. YouTube user Candy with a K says, good morning. I hired an attorney recently. I told my employer has in-house counsel. They want to talk to my attorney ASAP. What could that mean? Are they worried? Yeah, sounds like they want to have a settlement discussion. They also want to make sure they're getting a full idea of what's going on, so maybe they can fix the problem so it doesn't go any worse. A little bit of triage, keep the claim from getting bigger. Ronix Macaria, should I represent myself or continue to look for a lawyer outside my city? So I would look, Ronix, we have a ton of videos on the channel about pro se litigation, like representing yourself. And people get really mad because there's a lot of pro se litigants on this channel. And I don't want to make them mad, because some of the pro se litigants on this channel are actively incredible. They're doing great jobs. And there's also other YouTube channels where people like represented themselves pro se for most of their case and did an amazing job. With all those caveats, let me say this. If you and I were family and you represented yourself, every single time I saw somebody just gave me money, I appreciate that very much. You're wonderful and I love you, but you should keep your money. Ronix, if we were family and you were like, I'm going to represent myself, every time I saw you for the next 3 years, I'd be like, hey, Ronix, why you hate yourself so much? Like, I would not want to represent you because we're family and that's a bad idea. But I would just like, it would drive me insane. Representing yourself in a complex litigation and complex employment litigation, like employment law is actively referenced as one of the complex forms of litigation. Always. Oh, nobody ever is like, oh, employment litigation is simple stuff. Never. No one ever says that. So even other attorneys, even other litigation attorneys who are in other, I messed up my hair for Pig Patrol when he wanted me to prove it's not a wig. even other attorneys who litigate every day come into this field, take an employment case, and just commit malpractice like wholesale. Like happens all the time. There's employment attorneys who practice in states where they're primarily in state court. And then they just take a case in federal court. And it does not go well for them. So, like, my point here is that it's not that I'm saying you're not a super intelligent human being who could do an amazing job. My point is that, like, people who do this for a living, who do, like, fields that are very, very close to this field, commit wholesale self-harm when they enter this field. That's just the reality of it, right? If I see a law firm or an attorney who does PI and employment law, I'm instantly nervous. And listen, it can work out. I've known firms that do it well. I chatted with one like a week or two ago and had a collaboration on it. But pro se litigation in this field is just an act of self-harm. That's just my thought. Okay. I'm going too long. I got to answer these questions. I got to be faster. C note 1906 says 90+% of cases settle as you and my attorney have said. When do most companies decide it's time to settle? We're in federal court in California for age and racial discrimination. We've started discovery. C note 1906. I can't tell you when most cases resolve, but I can give you an idea that generally speaking, the data from our caseload breaks down a little something like this. And this is going to be fascinating, I think. So about 15% of cases resolve in the first 3 months. About 80% of cases resolve between 3 months and 9 months. The remaining caseload resolves between 9 months and 4.5 years. That's what I can give you. That's what I know from my caseload. Ramona Hudson, you've done the damage calculator and it says 120K. I love that for you. I hope that's a good result for you. F-16 Raptor. I hear the F-16 Raptor is pretty serious business. Mr. White, morning. Hello. Morning from Cali. Thanks for doing that. My pleasure. Helping more than my lawyer. I don't love to hear that. I hope your lawyer earns her or his money. Do I have to accept arbitration? And is it a lies about arbitration agreement during orientation? Could be a way to get out of it. So F-16 Raptor, I'm not allowed to tell you about the state laws of California. But the state laws of California are extremely relevant to your question as to whether or not you need to accept arbitration. Now, whether or not it's a lie, that's a factual question. And I don't know if it's a lie or not. But if they're going to enforce arbitration, they're going to have to show you the arbitration agreement in which you agreed to arbitration, to my mind, right? So one thing I would raise, potentially here is you got a lot of really good options in California for employment attorneys. I think California might have the most options for employment attorneys of all the states. Now, it sounds like you don't love your lawyer, and that makes me sad. So if things are really early on, you could look at switching things up, this or that, right? And I don't know why you don't love your lawyer. Maybe you're being reasonable, maybe you're not. I don't know, but I'm just saying if you're not happy, lots of people. The YouTuber who's in California, who I know might be able to answer your question, and actually has a video about, I believe, mandatory arbitration in California, is Brannigan Robertson. I actually have a video disagreeing with some parts of that video, but I tell you, the bulk of that video is fantastic, and he's a handsome fella. I hope he might try to help you out. But I'm not allowed to tell you the state laws of California. So there's that. Mystery is still being my story is still being written. I'm sorry, I did not get your username correct at first. Vince, my case didn't settle in mediation. I'm sorry to hear that. I went back to the EEOC investigation 2 months ago. I and 3 others from the same company have open cases with the same employer. How long does an EEOC investigation? That's just the end. There's nothing more. Okay. So I'm assuming you're asking how long an EEOC investigation goes. If you're not represented, anywhere from, 3 months to 4 years is the reality for the EEOC. Gamer Herold says, "You're so cool. Wish we can game together." Gamer Herold, I am not cool, but we can game together. I am playing Team Fortress Tactics for League of Legends. So one game mode in League of Legends these days. I'm also playing Helldivers 2 and something else these days. Listen, I'm happy to game. Like, I'll put up my like gamer tags if you want to. I don't have a ton of time these days, but if I'm on, I'll certainly play with you. YouTube user Kelsey, is it illegal for the employer to alter or destroy documents during discovery? Yes. Very much so. Yeah, that's going to be a huge, especially if you can prove they're doing it, it's going to be huge for you. Po Girl 2011 says, "Hi Vince, what is the best way to submit a case to an attorney? Timeline format or summary? What particular points do you all want to see? I don't want to give too much info if it's not necessary." So Po Girl 2011, I will say this. We have a playlist of videos on how to package your case for attorneys that I would hit up. That's going to have all my thoughts over the course of the past couple of years and a couple hours of content on the specific topic. That being said, when you are talking to intake, remember that intake is exhausted and they're routinely abused. Like, a lot of potential clients are incredibly abusive to our intake people for whatever reason. I think it's just because when you lose your job, you're going through a tough time and maybe you scream a little bit, or you're on the phone with someone. You keep asking if they're a robot for 20 minutes. Like, "Are you AI? Tell me you're AI." And our intake people are like, "Still no. What's wrong with you? Like, I'm not AI." It's crazy. It's wild, I should say. It's wild. Now, that being said, summary. You hit the high notes, right? You want to hit the high notes, definitely. Get in there, make it look appealing, give the details later, but like, hit the high notes. Ramona Hudson, we have a bunch of videos on the channel about attorney's fees. You can absolutely ask in mediation that they pay your attorney's fees. Just remember that your attorney is not going to care that you're calling them attorney's fees. Like, if you're like, "I want $100,000 and then I want $40,000 in attorney's fees," odds are your attorney's going to take their percentage of the full amount, the 140,000, not just 100,000, right? Because you calling it attorney's fees doesn't matter to anyone, right? Because you would just call the whole thing attorney's fees, right? You're like, "Oh, I got $140,000 settlement, so that's all attorney's fees. So my attorney gets no percentage of that." Your attorney is probably not interested in that. Aaron R says, "Hey Vince, what's the one album you could always play on a road trip?" Aaron, I listen to a lot of Alkaline Trio because I'm an old man. And their older stuff, maybe they're like their second album. I'm like a Bad Religion, Alkaline Trio, poppy punk, a little bit of metal. I listen to some metal. Marine Carrium says, "Hey Vince, can I ask the EEOC to dismiss the respondent's position statement if they don't meet their low burden of production? Have you ever heard of someone getting the employer's statement dismissed?" I have not. I've never heard of that. Also, if they produce a really bad position statement, you would probably want that to stay on the record, right? Jet said to @Toxicolic, "I have a racial discrimination case in the hostile work environment in California. It's finally getting pushed forward after the deposition. It happened back in 11/22. Okay, so you guys are communicating with each other. I love that. Candy with a K is deleting messages. Candy, I can't answer the messages if you delete them. Whoa. People are giving money left and right. Folks, I really appreciate the dollars. I really do. I got to tell you, it's very kind of you. But I would prefer you spend that money on yourselves. YouTube's already very kind to me for whatever reason. Okay. I lost my video. I lost my place in chat. Kim. Are there any cons for accepting EEOC mediation? Almost never. It's just going to be a conversation about people giving you money, and you can find out a ton. I have a ton of video. Our mediation preparation playlist, like, not to be a broken record here, but we have like a lot of content on like why you might want to mediate and what you can find out at mediation and the advantages of it. So like, can it in rare circumstances be a negative? Yes. Is it a negative? No, it is not. Y'all, we just hit 60 concurrent. Like, it just dropped down to 50, but we hit 60 concurrent, which I think is tying our record of all time. So that's exciting. Kim goes on, my charge has been open for almost a year, and the EEOC just offered mediation. I haven't had representation. I'm still employed. Yeah, go to mediation. Why not? Big Will says, by law, does a business have to respond to EEOC or FCHR complaint? I mean, the consequences are fairly low if they don't. Big Will says, can I include case law studies in my interview questions, responses to the FCHR? Because at this point, I don't have a rebuttal to do because the respondent never responded. I mean, you can give anything you want to the FCHR, but I would check with the FCHR to see what case law they find compelling. There's a good chance the FCHR might find their own findings to be the only findings that they feel are compelling, just so you know. Mr. Cato ASMR says, does an employee have to say to an employer that the employee needs an accommodation when the employee has already told the employer about a disability and offered to give medical documents? Listen, it's a new or should have known standard. So you can argue the employer should have known you need an accommodation. Ideally, would you ask for an accommodation? Does that make a stronger, simpler narrative? Yes, that case is stronger if you ask and you're then not granted. You can still push a case, certainly, if they're aware of the disability and, you know, should have known you needed accommodations. Excuse me. We have a question from Unbeknownst Guy. Mr. White, now with this economy being so impactful and on the rise, what particulars can an expert witness, economist, they have both degrees, what's your opinion in the expert getting lower damages? I would argue that a bad economy means damages should go up for two reasons. One, inflation is, listen, inflation is not increasing at the pace it was previously increasing, but inflation is wildly impactful. So that's going to increase dollar values of cases. And also, in a bad economy, which we're in, kind of a significantly bad economy right now, it is harder to mitigate. It's harder to find a new job. So if an economic expert came into my office today and was like, hey, the economy's rough, so we got to go with lower damages, I think my answer would be, oh, thank you so much for coming. Can you get out? We will not be paying you. I will pay you for your time today, but like our engagement with you has ended. Unbeknownst Guy would be my thought. Silence is Golden says, his law office is national, call his office, and after you can sign with him. Always check your local options first. They're going to be a lot cheaper than us. Sorry. John Craig, is 216 plus docs too much for an EEOC case? Does the argument get lost? Love you, good sir. John Craig, I don't know. Do our damages calculation playlist. It might be perfectly reasonable for you. Remember that your case can go on a federal court, and the caps in the EEOC are not necessarily determinative because you would also have state law claims that would go in that federal court action. Andrew S. says, do I have a case if I'm a language therapist and the school district will fire me because I need to go to addiction rehab during the school year? They have an undue burden defense. I would argue they don't if it is your first rehab. I think there's case law to support that. Candy S., thank you so much for the $5. That's incredibly generous of you. Missy 1982. Missy 1982 sounds like a Pokemon reference. Good afternoon, Vince. Confidential settlement communication, is that considered a demand letter? Could be. You can make your demand letter a confidential settlement communication. A lot of confidential settlement communications are going to be just negotiations back and forth. Could be something goes on at mediation. Most mediations are confidential. Mr. Cato ASMR gave me $2.99. That's very kind of you, sir. I appreciate that very much. Incredibly generous of you. Sean S. says, once a verified complaint pursuant to Executive Law Article 15 has been filed with State Division of Human Rights, has it become public record? If so, does the employer get more concerned about that? It does not. It is not a public docket. Listen, it could be obtained in certain circumstances, but it's not a public docket in that way. Imunyan says, hey, on my demand letter, I have safety retaliation claim, but I was wondering if making a verbal complaint is still as valid as making an official complaint to OSHA. I mean, it's valid. Your verbal complaint is valid about a safety issue, but it's not as strong for your litigation because you don't because you need to prove that it happened. Whereas if you have a writing or a formal complaint, like that's easy to prove it happened. John Doe KCK says, holy shit. John Doe, hello. The Trauma Center, a place for healing, says, do you have better odds winning an MSPB or civil action on a constructive discharge case regarding failure to accommodate? I don't know. Yeah, I don't know. I would need to dig into that. I don't know the numbers on constructive discharge findings in those at the MSPB is the answer. John Doe KCK says, happy Labor Day, Vince. Happy Labor Day to you, John Doe. I hope all is well. It's good to chat with you. Marcella Lewis says, the defendants tried to enforce the verbal settlement agreement with the courts. So if they found it to be legitimate, wouldn't it be fair game for us that they breached? The coworker was voice recorded. Marcella, I think you're making an argument that you can make. That there's a breach when they share the settlement terms. The counter argument is we're trying to enforce the settlement sum, but we didn't have the particulars of the agreement in place yet, so there was nothing to breach. And the way you're explaining it to me, if I was an arbitrator and you came to me that there was a breach here, I don't know that I would find that particularly compelling, but I would certainly admit that you're making a legitimate argument, and I would treat it with respect and like really dig into it to make sure I'm being correct in that finding. But like, I just don't know how compelling that argument would be. Trap Reels says, I've been working for a tree company for about a month. That is rough work. I hope you're all right. My job called me Friday and told me to hold off on coming into work Tuesday because of my background check came back, but I have no major charges or neither. Yeah, you might have criminal record discrimination issues. You might want to talk to an employment attorney, a local employment attorney where you are. John Doe KCK says 4.5 years. Let's go. LMAO. Yeah, I love that attitude. Keep that energy. I love that very much. Trap Reels, I'm not a felon. Do you think they will fire me? I don't know, Trap Reels. I don't know what they found in your background check. I don't know what the laws are in your jurisdiction. Chris Ritchie said, let me slowly roll this chat up. Ooh, this chat is on fire today. Whoa, we are at 65 concurrent right now. Hey, folks, can we get some likes on the live stream? The likes help us a lot with the algorithm. All right, let me go back to Chris Ritchie's question or assistance. I'm not sure yet. Let's find it. Let's scroll. Vince. Chris Ritchie says, Vince, quick question on your YouTube setup. You just have a simple USB audio interface with a professional analog microphone. Need a setup for Zoom meetings. Yeah, so I started out using, maybe I can get it in the screen here, this blue Yeti YouTube mic, which is just a USB connector. And it works on this computer really well. You may remember the clicking on the channel, which John Doe KCK and a couple other folks on the channel helped me to diagnose and eventually fix. And eventually I ended up hiring a sound engineer to literally come in and fix the thing for me in my home. Can say this. Blue Yeti microphones, incredibly easy. But in my home setup at the farm, I moved to a more professional microphone that goes through a booster of some kind and like an external audio sound card. It's all a bit beyond me, but it removed all the noise and it was able to really improve my audio quality because I know that my audio quality was bothering folks on the channel. So we took some of that channel money that $1,500 a month YouTube just throws at us for whatever reason, and got a sound engineer and got some advice from John Doe, and we got everything fixed, and it's good. Chris Ritchie, if you want me to post what they had me purchase, I'm happy to do that. But I would say if you're just doing it for Zoom, I could probably say the Blue Yeti was a great option under a hundo. And it worked until it didn't. Worked amazing until it didn't. Silence is Golden said, to all the pro se people, I was going to go pro se when I found this channel. I watched actual summary judgment videos, and while most had all the evidence, they lost because of lack of procedure. That is, yeah, it's true. Like, just knowing the process can be a huge issue. Atlanta's Best 78 says, I signed a severance agreement. Does the violation of the ADA absolve the severance agreement? If the violation of, so most severance agreements are going to be a release of your ADA claims, assuming the ADA claims took place before the severance agreement. If the ADA claims somehow took place after, like if you returned to work and something happened after the severance agreement, those claims would still be alive. Also, I'm obviously not reviewing your severance agreement, so I can't tell you that your severance agreement absolutely was a full release of your ADA claims. I'm just telling you that the point of most severance agreements would be to wipe out and be a full release of all those claims. So just, that's worth knowing. Okay, let me take a moment to look at my emails to see if things are blowing up. Are things blowing up? They're blowing up. Things are blowing up. Not in a bad way, just a busy way. What is happening in the world? Why don't people respect Labor Day? Why do they work? Why am I working? Insert promo here says, I thought about pro se as well, but then I remembered I have some serious ADHD and would rather allocate my spoons towards getting into medical school. I don't think I've ever heard that phrase before. Allocate my spoons. I would like to know what that means. I might start using that phrase. Medical school sounds amazing. Shiz says, YouTube user Shiz says, I'm a federal employee. Can ADR in this sector entail arbitration? Shiz, if you are dealing with a workplace discrimination or workplace sexual harassment case as a federal employee, it goes through the EEOC, generally speaking, and likely not through arbitration. My story is still being written says, yes, back to your comment. Yes, I and the 3 other employees are being represented by a local firm. Does this help? It does. When you have representation, EEOC matters often take less than 9 months. Almost all the time. Gamer Herold says, I have an itch on my foot. Oh my God. No. Help me. Okay. That's better. All right. Gamer Herald says, yes, thank you. I like your gamer tag. All right. I'll post it up in the comments. I got to go on Steam and see how one posts a gamer tag. I'm not like a game streamer, so I don't know like the smarty pants things to do. What game do you want to play, Gamer Herald? What? I feel like we're in like a movie in the 80s. Do you want to play a game? Was that War Games? I don't know. Atlanta's Best 78 says, oh my God, my foot is so itchy. Why is my foot itchy? Atlanta's Best 78 says, my employer made my termination coincide with the ending of my short-term disability. I had no performance improvement plan, no complaints, and my separation letter just listed severance. What do you think? I think it's time to talk to an employment attorney. Indeed. I think it's time to talk to an employment attorney. John Doe KCK says, hey, Vince, hope all is well with you and the farm. I hope everything's well with you, John Doe. I'm a week into an automotive technician program at a local school. Oh, that's sick. And congratulations. And loving it. So yeah, I'm going to be my midlife pivot instead of law. I can't do 80-hour weeks despite my aptitude, etc. When everything is said and done, I can at least return your favors by being your car dude. John Doe, that's amazing. I love that. I am trying desperately to go all EV. I love my electric truck, which is not a Cybertruck. Don't slow down, everybody. Slow down. I don't have a Cybertruck. I have a Ford F-150 Lightning that I love. I love the lack of maintenance required. It's amazing. I also love that it's less than half the price of a Ford Raptor, but like significantly faster and more capable. And I love how the Lightning is super useful for the farm. I also love that my solar array just charges my truck now. So my truck runs for $0, which is amazing. Travis Bailey says, I discharged myself due to a hostile environment that was created after witnessing unsafe work practices. Mediation is November. Plenty of evidence. Should I consult an attorney? Thanks, Vince. Travis, I would always recommend talking to an attorney. I think it's just helpful. Like if we were family at the dinner table, I'd be running my mouth trying to get you to hire an attorney. No question. YouTube user Kamani says, my mediation is on Wednesday via Zoom. I'm super nervous. Any ideas? Yes. My idea is watch our mediation preparation playlist. There's like 30, 40 videos in there, like a couple hours of content on getting ready for your mediation and things to think about during your mediation. And I can't stress enough that I think it's a really good idea to watch those videos. One moment. Apologies. That was really rude. CM Nola says, all the HR team told me when I complained was the case was closed. How is that going to be useful for me if they deny any wrongdoing on their part? Yeah, so they failed in their affirmative duty to investigate properly. I think that's going to be really valuable for you, realistically. I think that's going to be a potentially good part of your case, assuming, listen, I don't know anything about your case, but it sounds like that would be good for your case. It's a good piece of your narrative, a good piece of your story. Daniel Miner says, is it typical for the EEOC to take forever to schedule mediation appointments after both parties agree to mediate? It can be, yeah. The EEOC suffers from government employee disease. And listen, there are amazing government employees out there. I know people get a little salty when I say this. There are amazing government employees, but they are the exception to the rule. The rule is government employees, they're not all created equal, and some of them don't necessarily do that much in their workday. Candy, I'm so glad I answered your question. That makes me happy. John Doe KCK, what's up with the new ring? You got married, right? We don't talk about my personal life. John Doe, we don't talk about my personal life. And just so I can explain why we don't talk about my personal life, there's been some, how do I say this? There's been some folks who got the wrong idea from this channel. And they've done some things and said some things and showed up some places where they weren't welcome. And it's created some issues for me. So I don't discuss my personal life at all on the channel. And that's just not on the channel. Oxford, YouTube user Oxford says, does New York Division of Human Rights conduct a more thorough and effective investigation than the EEOC, which often only results in a right to sue letter with limited outcomes? I do feel that the State Division of Human Rights does a more thorough investigation. I often use the New York State Division of Human Rights to get free discovery. Listen, there's certainly some investigators at the State Division who I know don't even read their files, but on average, most of those investigators, and I'm thinking of like some really good investigators off the top of my head, actually care. Like shockingly, and they'll do things. And yeah, I do think the State Division does a better job, generally speaking, than the EEOC in terms of investigation. CM Nola says, can you recommend a lawyer in Georgia? CM Nola, I am not allowed to recommend lawyers. Our malpractice insurance carrier feels very strongly that if I recommend or vouch for a lawyer, especially on this channel, but in any setting, that I would then be liable for whatever they might do in the future. So like if I like, oh, this attorney in Georgia is amazing, and you go hire that attorney and they commit malpractice, our insurance carrier feels that you could then sue us as well as that firm. And they would not insure us anymore if we did that. So I'm not going to do that. Sorry. But you can, we have a playlist of videos on how to shop around locally that you might want to hit up. That might be helpful. Holy guacamole, people. We have 79 concurrent people on our live stream right now. This is, I believe, 19 higher than the old record. You're all fantastic. Thank you so much. Chris Ritchie says, I have a solution to all these backlogged employment issues and cases. Take the political funding away from the corporations as well as the union political funding. Yeah, listen. The union involvement in politics concerns me, but also I don't want unions to not be in politics because when they don't have a voice, unions get broken pretty quick. So complex problem. The YouTube user, the Trauma Center, a place for healing, says, I have a strong case according to my attorney. Glad to hear it. And just had a good deposition. Amazing. It is tough to have a good deposition, so I applaud you. Sincerely. I have another case for constructive discharge pro se. I want to file a civil action in case 2 for leverage. Is this wise? I don't know. I mean, if it's tied to the same facts, I'm pretty sure your attorney is not going to be thrilled with you if you do that. I also don't. Okay, let me just read it again. Let me make sure I understand. You have a good case going, so step. You have an attorney for that good case. And there was a constructive discharge. So you resigned, and you're saying you had to resign because things were so bad, I assume. And you want to pro se file a new civil action for additional leverage in your first case. Have you talked to your attorney about this? Because, listen, I don't know the situation, but if you were doing that and I was representing you, I would not be pleased with you. Because, a variety of reasons, including your pro se litigation is going to expose so much risk to your existing case. Just my take, just my thought. Sage Page, how are you? Sage Page says, OMG, I'm glad I caught your live. Sage Page, I'm glad you caught the live as well. Oh my God, we have 84 concurrent users and 48 likes. We listen, this is amazing. This is the biggest we've ever had. Labor Day Extravaganza. I don't know. Flying Over Trout says, hi, Vince. Happy Labor Day. Happy Labor Day to you. Glad you're educating people on their rights and advocating for them. I really hope that we are providing some value here. Will to Change. Great username. My CIO, chief CIO. My new CIO hired a new lead, which I am training. I was more qualified. Could I do something about this? I'm an African-American male, very upset. I think I'm being quiet fired. So, Will to Change, if you think that you didn't get that promotion because of your race, then yeah, that's a potential claim. If you think that you just didn't get that lead because, some other reason that's not tied to a protected class, then maybe not. CM Nola says, my case has several elements: discrimination, slander, sexual harassment, and disability. CM Nola, don't be surprised if attorneys are not interested in the slander component of that case, but the discrimination, sexual harassment, and disability sound amazing, potentially. You should definitely talk to attorneys about that. CM Nola says, I have not found a law firm to structure my case. Yeah, so a lot of times when you try to stick that slander claim in there, law firms will lose interest and not want to represent you. And I don't know the strengths or weaknesses of your slander claim. I don't know them, obviously. And I don't know what the laws are, where you are, or any of that. I'm just going to tell you that most of the time when somebody walks in the door with a slander claim, most firms in this field will say, hey, we like your other claims. We don't like the slander claim. You can give up the slander claim, or you can you can bring it with another firm, but we're not going to bring it for you. And that's if they're really hearing you out and doing right by you. A lot of firms will be like, nah, I don't want to deal with you because you got the slander claim, and they'll just walk away. Just a reality. YouTube user Kinsey says, question mark, investigator emailed an update, now submitting an investigation plan to their legal department and would be requesting documentation and testimony from my employer. Hire an attorney now or wait. You might as well hire the attorney now. So I assume you're going to probably hire an attorney on a contingency, or at least primarily on a contingency, even if it's a hybrid, even if you're paying something up front. So the sooner you hire them, the more time that attorney has to earn her or his fee, right? And there's more they can do to reduce risk and add value. So I would urge you to, potentially consider hiring your attorney as early as possible. Excuse me. YouTube user Tiffany Zamore says, I was recently discriminated against at work due to my religious beliefs in Florida. Do you serve Florida State? So we do practice in all 50 states, specifically workplace discrimination, workplace sexual harassment. That is not the point of this live stream. I'm not trying to get clients. I would always urge you always, always, always consider local counsel. Local counsel will be cheaper than our firm. Many local counsel can do an amazing job, and Florida does, especially in the Miami area, have a number of good and talented employment attorneys. I actually briefly worked for, well, I did depositions for a firm out of Florida like 15 years ago. They had some cases in New York, which was weird. And I did depositions for them. And then I like 6 months later, I walked into like a meatball shop, and like the owner of the meatball shop tried to like fight me. And I had no idea, like no idea what was going on. And it turned out that I deposed him, and I guess I had gone rather hard in the paint for this. I deposed this guy, this gentleman, as part of what I did, like taking depositions for this Florida firm. I must have really been earning my money from this Florida firm, because this guy was ready to ended up in the parking lot. I'll tell you that. The authorities were not called. There was no need for the police. YouTube user Shiz says there are findings of discrimination in the ROI. Agency offered $50K, but damages are around $600K. Can ADR at this stage lead to a settlement for these kinds of dollar amounts in a federal sector case? Yeah, I don't see why not. Listen, if the damages are actually $600K, and it sounds like you have a strong fact pattern, and they're at 50, you're at 600. Listen, is there a number between 50 and 600 that you can live with? If the answer is yes, then I think there's a chance that the case can settle. Absolutely. All right. What do we got? YouTube user Oxford. Whoa. Chat, why do you jump ahead? Chat, why do you jump ahead of me? Let me find the question. Chat, why do you do this to me? I just read a comment from YouTube user Pamaroon. Hey, Bubbles, miss you. Happy Labor Day. Just that microphone looks very inappropriate. So now I feel self-conscious, and I will be moving the microphone out of the window here. Okay, YouTube user Oxford. Does the New York Division of Human Rights conduct... Oh, I think I already answered this one for you. Okay, I did. Maybe I went back too far. Did you ask that twice, or did I go back too far? YouTube user CM Nola says, what would a sexual harassment case, discrimination case against a larger retailer would be FARI? Would be fair? Would be for? Oh. What would a sexual harassment case, discrimination case against a larger retailer settlement would be? Got to do damages. So we have a playlist on this channel of how to calculate your damages. There's a bunch of videos there. You got to watch that playlist, take that information, apply the facts of your case to that information, and you're going to get a valuation. There's no like, so you're saying things that are not relevant to the valuation of your case. It's a sexual harassment case. Great. Sexual harassment cases tend to be valuable, but that's the only thing you can extrapolate from the fact that it's a sexual harassment case. And a larger retailer just means like it can be in the EEOC. Like you're probably filed in a good venue. Like they can probably pay. Those are the only two things you get from the information that you're posting. Everything else, you're going to have to apply the formulas and do the damage calculation. Insert promo here says, I asked for my accommodations before started working. When I was asked to submit documentation for my provider, the manager told me she would rather fire me because HR is a headache. Oh, okay. Well, that's a claim. Talk to local employment attorneys right away. CM Nola says, you asked for $5 million if you are trying to settle for $1 million. You should do a damages calculation playlist and hire an attorney if you are to have any hope of a 7-figure settlement. Listen, I don't know what your case is worth, and I don't know situationally or tactically the realm that your case is in. You would generally go a little bit higher than where you want to end up in settlement demands, right? Like that makes sense as a general thing, but like the tactics of settlement negotiation are endless and varied and complex, and are probably go beyond what I can advise you about without knowing the situation. And I'm not going to be able to know the situation. But I do think you should get an attorney and look at our damages calculation playlist. All right. Dukes VR says, what is common for front pay? There's no common. Every case is different. My attorney approved 3 extensions to answer my federal complaint. My attorney approved 3 extensions. Oh, to give them extensions of time to answer the complaint. And filed a joint motion to stay until November for mediation. We demanded 100 weeks for ADA FMLA claims. Yeah. I mean, listen, I don't know your claim, so I can't necessarily say if 100 weeks is good or bad. But I'll say it certainly doesn't sound like your attorney's trying to flip your case. I'll tell you that right now. I would say, like, it sounds like somebody's trying to do right by you, and is handling your case in an intelligent fashion, potentially, without signing off on that number. I can't speak to that number. CM Nola says, if you sent the complaint letter to HR and they didn't receive it or claim to have received it after the firing, is it still considered retaliation? Yeah, you're going to have to prove they got it. They're going to try to prove they didn't get it. You're going to have to prove they got it. And you're going to certainly argue that retaliation is in play. Sage Page says, my lawyer said my case will be mediated by a federal judge because my employer is trying to lowball the settlement. Is that a good thing to have a judge mediate or to go to trial? So having a judge mediate a case, it can be really amazing. I've had some really wonderful moments with judges. And what they'll often do is have a magistrate judge come in and, like, it's not going to be the judge who's going to hear your trial, generally speaking. They'll have, like, somebody come in and just adjudicate the situation, and hear the facts, hear the arguments, and be like, okay, so I'm not really a mediator. I'm a federal judge, and I got to tell you, I think you should pay this person. I think you should pay Sage Page X amount of dollars, and that can be amazing if you like the number the judge says. It can also be kind of a bummer if the judge says, she or he is just like, Sage Page should get $100,000, and you're like, no, judge, I don't want a penny under $600,000. Judge doesn't care. Judge is like, yeah, I don't think the case is worth that. I heard the arguments. I think they should give you $100,000. Now, you don't have to accept $100,000, but there's a little bit of pressure too, because now we got a federal judge here telling you what to do, right? So listen, it's not the end of the world, and I think it could be, like, a really good thing for your case, but, like, there's a hint of risk there. And also the other side, if you're demanding $600,000 and the judge is saying, just 100, just give him 100,000, the other side's not going to be, like, pumped to give you 600,000. I'll tell you that right now. They're going to be like, but the judge said only 100,000, so you should take 100,000 because we'll give you 100,000 because the judge said 100,000. That's the downside. The upside is powerful figure, hearing the facts of your case, and advising settlement. That's good. That's a good thing. All right. YouTube user Avatar of Justice says, is it better to have a lawyer who specializes in OSHA cases if OSHA is involved? Yeah. I think you want somebody really well-versed in OSHA. A lot of employment attorneys will have a lot of OSHA experience. I would just make sure your employment attorney has practiced in OSHA before. YouTube user Kamani says, hello, my mediation is on Wednesday. Any advice? Oh, I already answered this one. All right. Will to change my new, I think I already answered these. Did the chat, like, roll back? Avatar of Justice says, what special OSHA protections apply after a settlement? Can the employer still say negative things about me? So you should have protections against retaliation. If you feel you're being targeted for negative, like they're doing negative things to you or saying negative things about you because you filed that OSHA claim, you have retaliation protections, and certainly will have some options. Kelsey asks, what are some telltale signs that an employer will settle? They want to have settlement negotiations. I mean, statistically speaking, overwhelmingly, employers will settle in this field. So, the only employers that, the better question is, what are some signs that an employer won't settle? And I will tell you that the best sign is when defense counsel calls you up and says, yeah, I got to tell you, I'm going to bill this one to the end. You're not going to get $1 on this case unless you win it. My client doesn't want to give you 1 red cent. And I assume the phrase red cent is like something to do with like blood money or something. I don't really I don't know. It occurs to me that it could have some racial issues. So I'm now worried that I said it, but history, very ugly. Yeah. So most employers, Kelsey, do want to settle. Insert promo here says, can I get emotional damages if the employer is a public university? If you are using the federal laws, the answer is yes. To bring a discrimination, a workplace discrimination, workplace sexual harassment claim, the answer is yes. YouTube user Mike Plot says, when calculating damages, is back pay, front pay calculated as part of the max 300K or separately from the pecuniary, non-pecuniary damages? So Mike Plots, this question, I feel, is going up the wrong tree, and I'll tell you why. You have your federal claims, but realistically, if you're in the EEOC, you're on a path potentially to federal litigation. And in federal litigation, depending on where you are, you're also going to have state and local law claims. And those state and local law claims may not be subject to the same caps that you're dealing with in the EEOC. So rather than wrestling with these caps, better perhaps to have a conversation with local counsel about, hey, how much could I actually win under the state and local law claims? Am I actually capped? Because you might not need to be structuring your settlement to stay under these caps, because your argument is, hey, yeah, we're in the EEOC today and we're using one set of laws, but frankly, we're only in the EEOC today because we don't yet have a right to sue letter, and we might be going to federal litigation. And at federal litigation, I'm going to be using 2 or 3 sets of laws, federal, state, and potentially local. And once we're there, I'm not going to have to deal with these caps. So I don't have to conform my demands today to those caps. I hope this helps, Michael Plotz. Poor Girl 2011. How often do workers' comp cases? Nope, don't answer workers' comp questions. Not a workers' comp attorney. Well, all right, fair enough. This is EEOC. Okay. How often do workers' comp cases merge with EEOC claims? Never. Could EEOC claims affect the settlement of workers' comp claim? No. The workers' comp settlement. Listen, if you engage in some kind of global settlement at the EEOC and you're like, your settlement agreement's like, I settle everything and including my workers' comp case, then yeah, I could absolutely do that. But as long as you're doing a carve out for your workers' comp case and you're following the advice of your workers' comp attorney in terms of protecting your workers' comp case, should be fine. Workers' comp settlement continues to get pushed back. Could that be the employer? I mean, it could be. Yeah, could certainly be the employer not wanting to pay or trying to put things off. Absolutely. YouTube user Sam K says, will the company owner get into trouble for calling in a witness or asking if he will change his statement? Potentially, yeah. Witness saw owner of the company sexually harassed me at work, text witness and asked him to, the owner texted the witness and asked him to recant. Yeah, I think especially if you have that evidence, you have that text message, that could be incredibly valuable to your case. Marine Carrium says, hey, Vince, if an employer submitted 2 position statements a year apart and gave shifting and inconsistent reasons for my termination, should I answer the second reason for discharge or scream pretext? You should do both. This is a pretext. And also, this is clearly, and here's why, this is clearly not the reason for termination. And also, you've given 2 reasons. Which one is it, tough guy? Right? Like, lots of great arguments to be made there. All right, it is 1:12 p.m. We are going for another 50 minutes. 50 minutes. I mean, a little time. I need a little time to eat, so maybe not a full 50 minutes. Sam K, I cannot tell you if your case is strong or not because I don't know anything about your case. I'm sorry. I can tell you that the fact that you just relayed to me is a strong portion of your case, and certainly makes me think your overall claims might be strong, especially because that you have the owner trying to play defense here and trying to get witnesses to recant. That means the owner's probably running scared, right? Unbeknownst guy says, so my case has many variables, not investigating witnesses, inconsistencies in stories, exculpatory evidence, hiding. How would you address defendants' representatives? Too many elements happening. How would you address defendants' representatives? So I think you mean, how would I speak with defense counsel? With a demand. Like, it sounds like you have a strong claim that you're describing there, and I would give them a demand. Be like, hey, a lot going on here. We're going to mess you up. Or you could cut my client a check, and my client would take this much. What do we have? Vanessa K. Allman says, Vince, should I trust that external investigation brought in to investigate racial discrimination is truly independent and objective when paid by the organization? Not at all. External investigators are doing exactly what HR does. They are there to protect the employer. Always. All right. Mr. Cato ASMR says, Vincent, fighting against a state government entity is just horrible. It can be, yeah. We have a lot of cases against state entities. We're one of the few firms in the New York area, the East Coast, that will take cases against state and city entities, and it can be a nightmare. Yeah, it's always so much extra work. They keep the litigation going and going. This is Mr. Cato ASMR. The judge is fed up with the defense attorney. It's just a waste of time with them. It is. Yep, that is all true. CM Nola says, if you sent the complaint letter to HR and they didn't receive it, oh, we already answered that. John Doe KCK says, I'm afraid to game with you, Vince, because I'd find out you're heterophobic or something. Seriously, gaming brings out the worst in people. You feel that I hate heterosexual people? I do not hate heterosexual people. I guess you imagine me just like screaming hateful things at heterosexual people on like live chat in a game. That is not something I engage in. Also, so many assumptions. Octuple Threat says, amazing. You're going to teach me what the spoons are. Your spoons are a metaphor of your energy and ability to handle stresses of life. The idea is to recognize the things that cause you mental distress and exhaustion and to budget spoons appropriately. That is an incredible amount of wisdom. Thank you for explaining that phrase to me. I love that is a thought process you're engaging in, and it's fantastic. And I will try to incorporate that phrase into my lexicon today. Sam Nola says, if you answered that, what usually my story is still being written, says what usually goes on in an EEOC investigation when multiple employees have open cases against the same employer. Pretty much the standard. Yeah. So the EEOC often doesn't actually investigate. They just see if people will mediate, read the original charge, get a position statement, read everything, and issue right to sue letters. If there's enough people, they could send it to enforcement and do more, but that is incredibly rare, like less than 2% of cases, I believe. YouTube user DFS21 says, is it common practice for attorneys to file claims under both 42 U.S.C. 1981 and Title 7 of the Civil Rights Act? If so, what are the benefits of doing so? It is common practice where appropriate. And I mean, the advantage is in part that those laws have slightly different, that were drafted differently and have different case law tails. So there are some advantages to both sets of those laws. Also, on a verdict sheet, there is more potential places for a juror to click that your client won. And that is a bigger deal than you would think. So that is why. Yeah, you want to, wherever appropriate, bring all the claims. And so you're going to be doing Title 7, 1981, and then all the state and all the local law claims that are appropriate and viable. You don't, if you can help it, leave claims behind. All right. Atlanta's Best 78 says, excuse me, I have email correspondence between myself and my old manager speaking to, her mistreatment from the same VP. Must be relevant for my case. Yeah, I would think so. As long as it gives some information about discrimination or retaliation or sexual harassment, then yes. Okay. Will to change. My new CIO hired a new lead. Oh, answer this question. Okay. We do have people asking questions multiple times. That's okay. I don't want to answer them multiple times. YouTube user Joy says, I have contacted many attorneys for my employment discrimination case. The EEOC suggested a mediation for my case, which my employer declined. What can I do when no attorney is taking my case? So if you can't get local counsel, talk to the national firms. Would be our recommendation. Certainly. YouTube user Pamaroon says, how should one handle friends, family, or people who know about one's case and where a settlement was reached and they know a legal binding non-disclosure settlement agreement has been reached? You can't tell them the details because they're going to out you. That's just human nature. Like there's something about secrets that humans are super bad with. And like, I can tell you, and this is not exaggeration, that this firm would have 7 figures more in its coffers today if people could shut up about their settlement figures. There's a lot of people who breach or who tell people who then breach, right? Like it just happens. And like when you're talking to the client, you're like, listen, you need to not, I know you hear me and you're looking at me like we're talking and I'm telling you, you can't tell people what you got. They're like, yeah. Okay. Not going to tell anybody. And then like you walk out of the mediation with them or whatever, and they're typing away and you're like, excuse me, who did you just text that number to? Oh, my accountant. Yeah. You text your accountant like that. Who was it? It was my sister. Okay. Who else? All my coworkers. Oh, okay. So we're done. You're not going to get this money. Okay. That's fine. You hate yourself. It is what it is, right? Avatar of Justice. What are you sorry about? There's nothing to be sorry about. I don't think you did anything to me. I don't think there's anything to be sorry about. Did I say something rude? I'm so sorry. Toxiholic says, if the EEOC found merits in your claims, how much weight does the EEOC hold? Not really much. They're just going to give you a right to sue letter, and you're going to go on and have to win your case in federal court. Octuple Threat says the metaphor of the spoons is often used by neurodivergent people to explain their limit on the number of stressful things they can do in a day before they suffer mentally, similar to the concept of a social battery. That is incredibly useful and intelligent. That is a great way to approach that topic. I love that. Goose 8 Duck says, motion to reconsider arbitration decision filed before arbitration decides. Can 200-day kick out to be used to file in district court for a de novo hearing instead of only a review? I don't know. Motion. So you lost an arbitration decision and you want to appeal the arbitration decision, I think. And so you're going to you want to do a de novo hearing in a district court. So I assume you mean a federal district court. I don't know the procedural history of your case. I can't tell you if there's any merit to that approach or not. I'm sorry. Insert promo here says, speaking of farm, I'm hoping to start a sponsored community garden in Imo State in Nigeria. That's incredible. Insert promo here. That is really, really amazing. YouTube user Jen says, sorry, but the EEOC doesn't care about us. So that is functionally true, but there are people within the EEOC who do care. I will say that. So like some percentage of the people who work for the EEOC are like true believers. Like I always give the example of Deborah Wright out of the New York City office. She's this amazing mediator. She really cares. I think she's amazing. And like, the exception that proves the rule of what you're saying, Jen. All right. YouTube user Susie B says, hey, Vince, thank you for straight up great info. More than welcome. I was transferred to a new position after 20 years on the job after OSHA and workers' comp complaint. Previous job was given to somebody 20 years younger on a PIP. OSHA not fired. Too bad. Union blah. I mean, that sounds like a claim to me. I'll be talking to local counsel right away. YouTube user Masked Mentor says, early in my career, I wanted to be an attorney. At this stage, I don't have the desire to attend law school. Would mediation be a viable option? I have an MBA and a degree in accounting. Yeah. Listen, mediation is a great process. If you want to get a settlement, mediation, or even just find out some important information for your case, mediation can be a great option. I'm happy to help. Atlanta's best. Thrilled to help. Joseph Ahura says, "Hi Vince, how do virtual settlement conferences work? As the client, would I be in a breakout room? Do I ever address the judge?" So virtual settlement conferences are going to be different, and they're going to be structured probably by the court attorney, and different courts will do them in different ways. But I think you should certainly be hearing what the judge says, and you might be in a breakout room. That might be a process the judge used. Yeah, but I can't tell you specifically how they're going to do it. John Doe KCK says, "Well, the ring looks good on your finger for whatever reason you're wearing it. Congratulations. I didn't mean to touch the third rail. No problem. Sucks that actual crazes beyond help have threatened you, etc." It's been a weird 12 months, John Doe. I'll say that. It's I don't know what it is about this channel, but it's generated some issues. And I'll say this. So like famous people have, because obviously I'm not famous, have like apparatus built up to protect them from stuff like that. And I didn't. And so things, escalated. And it's expensive to build that apparatus. And I didn't know that. It never occurred to me that I would have an ask and answer YouTube channel and then have to spend money to protect myself because I had an ask and answer YouTube channel. It gets a little expensive. I'm not going to lie to you. Everything's great. And then it's not. But it's fine. Certainly, it's fine. Jorge Zelaya says, "Hi, Vince. I emailed my HR department to cite the policy for my separation, and they have refused to respond. What could that possibly mean? That they don't want to say anything to you that might be useful in litigation, I suspect." CSM 8119, so happy to catch you live. I'm so glad you caught the live as well. Oh my gosh, we have 90 concurrent. That is 30 over our old record of 60 concurrent viewers, I believe, in a live. That is thrilling. A Labor Day miracle. Octuple threat. Oh yeah, octuple. I've been doing a lot of reading on parasocial relationships over the past 12 months. So I'm going to read octuple threats comment here. Octuple threat says, "Parasocial relationships are a thing that happen, and unfortunately the direct interaction can feed it. When I put in an evaluation with your firm, I consciously chose not to bring up anything that I learned about your firm from your channel. I just wanted to speak about the merits of my own claim and didn't want to sound like I knew anything. The more I learn, the less I know." Octuple threat, you are a gentle person and a scholar, certainly. Thank you. Yeah, parasocial relationships are tough because there's very few of you all, there's 100,000 subscribers, whatever it is, 115,000, something like that, who watch this video somewhat regularly. I know a lot of people are like, "Yeah, I have my coffee with you every morning. I just watch your video while I drink my coffee." And it's like, that's awesome. I'm really glad that's amazing. I hope it's useful in some way. But a lot of those folks forget that I don't watch them, right? It's not a two-way street. So I'm just throwing a video into the world, and then I go about my day. And then, if somebody spends 30 hours watching my stupid face, my stupid pink, right? They might feel that they formed a relationship when I didn't have any interaction with them at all, So that creates some issues, I think, for some folks. Goose 8 Ducks. Oh, I answered that question, I believe. Oh, chat jumped ahead. Chat, why do you do this to me? Oh boy, we got a lot of questions. We're not gonna. I wanna be up front here. We're not gonna get to all these questions. I got 32 minutes left, and we got a lot of questions here. What do we got? Oh boy, we got a lot of questions. That's the downside of 90 concurrent people. We get a lot more questions. Okay. YouTube user Miho Tito says, Vince, I filed federal civil charges against my employer pro se. Okay. Wishing you luck. The response by the court was to direct me and my employer to ADR. Amazing. That's a good result, especially for pro se. Can I hire an employment attorney to assist me in the ADR process? Yes, you absolutely can. YouTube user Tanisha Sanders says, what is a good example of material fact in a wrongful termination lawsuit? So wrongful termination is generally not a claim in most jurisdictions of the nation. But if you're talking about like a workplace discrimination or workplace sexual harassment case, a great piece of evidence would be anything that shows that the discrimination in the workplace happened, or that the sexual harassment in the workplace happened, or that, retaliation happened. The Trauma Center, a place for healing, asks, thanks for the advice. Hope it was helpful. My current attorney does not do constructive discharge due to a high burden of proof, but I will hold off on filing any action. Constructive discharge isn't that high a burden. I certainly have plenty of constructive discharge arguments on my books, and I like them and value them. YouTube user Pamaroon says, how does AI play or will play into workplace discrimination? So Pamaroon, we actually have a video from like 2 or 3 years ago about an AI that was like doing hiring functions for a financial planning firm. And this is an old AI. Like AI has come a long way in those intervening 3 years, as we all know, I think. But this AI like learned that like from the data at the company that like people who played Division I football tended to do really well at getting clients for this financial planning firm. There's an obvious reason there. Some older folks watch a young Division I college player, and he does well for them in terms of like winning games for their alma mater, and then he becomes a financial planner, and they're like, oh, you were great when you won us the championship, and they want to invest with him because for whatever reason, which is a terrible way to hire a financial planner, but it is kind of how human beings often think. And so this AI figured out like, oh, these Division I college football players are the best financial planners because they get the most clients. Now, Pamaroon, to your point, that means that AI thought it should only hire Division I college football players. Now, to my knowledge, I don't know if there's a female Division I college football player, but if there is, I would suspect it's less than 1% of all Division I college football players that are female. So right off the bat, we've got a massive gender discrimination issue because that AI taught itself that overwhelmingly it should be hiring men who probably don't have a disability, at least not a physical disability, because they played Division I college football, right? So we got some discrimination in play already, and that case was quite the case study and something that was on my radar 3 years ago. And I would argue as AI becomes more complex and harder to understand, the situations are only going to keep getting worse. Now, there's a counterpoint in that AI is a useful tool in our industry, and we're certainly keeping our eye on that. So there's, it's not all bad. YouTube user Marine Carium says, if I raise an age discrimination complaint in a union grievance, is that protected activity? Yeah. Sean S says a C-suite and salaried employee usually is discriminated against more. Yes. The C-suite usually not as extreme. Is it discrimination when he suffered less gets more? Rhetorical. Yeah. I mean, listen, C-suite executives, their claims are going to be generally worth more because they earn more. But you're probably correct in that C-suite executives are less often targeted for discrimination. I actually don't really know about that because there's a lot of, I'm thinking of a couple of cases right now of some pretty serious gender discrimination and racial discrimination for that matter, and disability discrimination. So, listen, I don't think the C-suite's as safe as you think. Or counterpoint, the clients for this firm often, we get a lot of very high earning individuals who become our clients. And so maybe we just have an outsized amount of C-suite executives who want to hire us for discrimination claims. So maybe my perspective is, incomplete. Gigi, I don't generally answer slander questions. I'm just generally going to say that slander claims are often claims that employment attorneys are not interested in, but I hope that your other claims certainly do well. It sounds like you have retaliation claims, sexual harassment claims, absolutely. And 1 year is not so long, although I hope your lawyer is moving your case along. You're my boy, Blue. YouTube user, you're my boy, Blue says, how strong are audio recordings as evidence used in settlements? They're potentially very strong, depending. YouTube user Sam Nola says, when asking for a settlement, do you ask for the number that works for you, or do you go by the EEOC guidelines? So I would certainly calculate your damages as per the laws. Just making up a random number is almost meaningless because you can't substantiate it. And you wouldn't potentially, like, if you're just like, I'd like 30 million and it doesn't fit with the formula, like you couldn't actually win 30 million. The other side's going to be like, okay, well, I'd like a pony. Can you give me a pony? Like, you know, at some point they're going to be like, what are we doing? You can't win that. So why are you asking for it? Atlanta's Best 78 asks, is secondhand information admissible? Conversations, not text messages. So there's hearsay issues, but there are exceptions to hearsay. So the answer is maybe, but also you're definitely going to try, right? And also secondhand information, like there's ways to go get the firsthand version of that. So there's things you can do. All right. I'm kind of running out of time. I gotta like eat before I gotta go play tennis today. Hitting the wrong button. 91 concurrence though. That's tough. Hi, Marlana Beasley. I hope all is well. Marlana says, yeah, I caught the live. How long does civil court judge take making a decision on partial summary judgment? 3 to 9 months on average, I'd say. John Doe KCK says, if the employer-employee relationship has ended and the employer never asked for the equipment back, computers, at what point can they be tossed? Does pending litigation mean keeping in a closet just in case? It's been a year and I need the closet space back. I mean, a year, like, listen, I'm not going to tell you to toss them out because I don't want to, like, be at fault for you tossing them out. But I can tell you, like, if I had my employer's computer for over a year and I didn't want it, I'd be tempted to toss it. You might want to strip those hard drives to make sure your information is not on there, but you sure know better than I do. Yeah, I mean, 1 year is a long time. Certainly, if you have litigation open, you might want to hold on to it. Just it depends on how bad you need that closet space. The Trauma Center, a place for healing, says, how long does it take after summary judgment to actually receive a hearing? Completely depends. Depends on the jurisdiction, depends on the docket, depends on the judge. 2 to 14 months might be the best answer. All right. Marine Karim says, the EEOC said my work grievance didn't mention race, so it's not protected, even though I was implying race. But the employer acknowledges race harassment in the position statement. What you think? So those are two different things, right? So you're trying to say, like, hey, this grievance I filed contained a protected activity. It contained a complaint of racial discrimination. And the EEOC is saying, I don't see it. So listen, the EEOC is not the decider on that. Like, you can still take that to court and argue that it should be protected activity and that whatever came after should be retaliation. If that's what you're trying to argue, you can certainly do that. The employer acknowledging that racial harassment took place in the position statement doesn't necessarily mean that you engage in protected activity in your grievance, though. Those are probably not two of the same things. A Taurus Queen of Zion says, can I request an employer release closed caption TV footage of a sexual harassment settlement at a military camp? So I'm assuming you mean you're trying to get CCTV footage of the sexual harassment incident Yeah, you can certainly go after that. Go after it fast. There's a really good chance if it's past 72 hours, it might be gone. So just, get on that as soon as you possibly can. Oh, all right. It is 1:40 p.m. Eastern time. I am rapidly running out of time. I have to eat something before I go play tennis today. Otherwise, I'm gonna pass out. Thank you all so much. I need to do more live streams. I feel terrible that I'm not getting all these questions. There's so many questions left to answer. Oh my God. I'll never get to all these. I'm so sorry. Oh boy, there's so many questions. Isaac's Trade says, wait, you mean we are not buddies? Now I thought we had something special, Vince. Haha. We do, buddy. We're buddies. We're buddies. Okay, everyone. It was amazing seeing you. I'm so sorry I'm not getting to all the questions. I hope you all have wonderful days. I'm gonna try to do more of these live streams. This went really, really well. I loved it so much. It was great seeing you all. I'm sending hearts in the chat. Take care, everybody. Have a great Labor Day. And I'm going to be back to my regular uploading schedule for the rest of the week. Working hard over here. I hope you're all really well. Happy Labor Day. And everybody get ready for Striketober. I think it's going to be big this year. All right. Take care, everybody. Subscribe, comment down below, share the channel so it can grow.